2023 at 10:00 hours in the morning. I want to welcome all of you to this meeting. I will give the purpose of the meeting a little bit later. So I'm going to allow first, before I also welcome individual groups, I'm going to take attendance and apologies first. Ms. Majalamba, can you give me an indication of attendance and which apologies we have received?
Good morning and thank you, Chair. Present is Dr. Jacobs, Ms. Geller, Dr. Harvard, Mr. Baba, Dr. Nothnagel, Ms. Clark, and Mr. Van Staden. I've received an apology from Ms. Sugers, and Ms. Wilson will join the meeting around 10:30. Thank you, Chair.
Thank you very much. I want to also give an opportunity to the PLO, Mr. Joe Cutler, to give me an indication who has joined us from the department.
Mr. Cutler is only joining now, Chair. Maybe he didn't hear what you were saying.
Has he joined already?
Yes, Chair, he joined while you were talking.
All right, so Mr. Joe Cutler, Parliamentary Liaison Officer of the Minister, can you give us an indication who has joined from the National Department of Health?
Yes, good morning, Honorable Chair. Good morning, Honorable Members. My apologies, the network was giving me a problem. Honorable Chair, this morning the National Department of Health is led at the front by the Deputy Minister, Dr. Romo, Dr. Nicholas Crisp, NHI DDG, Dr. Gwena Tulare, and the rest of the team, or the DG, or Dr. Sandle Buthelezi is also in attendance, the Chair, and then other senior members of the department. Thank you very much, Chair.
Thank you very much. You're very welcome, DM, DG, Dr. Chris, Dr. Cholare, Advocate Mabelo, all others who have joined our meeting. I'm also going to welcome the groups, 3 groups, legal services groups, so that we are able to proceed. They're going to be very instrumental in our meeting today. Ms. Isaac, from the Parliamentary Legal Services.
Good morning, Chairperson.
Thank you. Ms. Johar and Advocate Johar and Advocate Hercules.
Good morning, Chairperson. Good morning, honorable members.
Good morning, Chair. Good morning, honorable members.
Thank you. Advocate Mabelo. Is Advocate Mabelo on the platform? I'm going to ask somebody from the department to contact him so that he can please join this meeting if he's struggling with connection, etc. But I would have to make sure that somebody very senior makes certain that he joins our meeting, please. Honorable
Chair,
members,
thanks. I'll do so.
Thank you. Honorable members, before we proceed, I would like to remind you that this virtual meeting is deemed to be in the precinct of Parliament and therefore constitutes a meeting of a committee of the National Assembly for official purposes only. In addition to the rules of virtual sitting, the rules of the National Assembly, including the rules of debate, apply. Members enjoy the same powers and privileges that apply in the sitting of the National Assembly. Members should equally note that anything said in the virtual platform is deemed to have been said to the House and may be ruled upon. All members who have logged in shall be considered to be present and are requested to mute their microphones and only unmute when recognized to speak. This is because the microphones are very sensitive and will pick up noise which might disturb the attention of other members. When recognized to speak, please unmute your microphone and connect your video. Members may make use of the icons on the bar at the bottom of the screens, which has an option that allows a member to put up his or her hand to raise points of order. The Secretariat will assist in alerting the chairperson to members wishing to speak. When using the virtual system, members are urged to refrain or desist from unnecessary points of order or interjections. I just want to make certain from you, Ms. Majalamba, is this a live broadcast this morning? Ms. Majalamba? So, honorable members, whether it is live or not, it is normally streamed by the parliamentary streaming services. I'm going to request you to switch on your cameras when you do speak, so that we are able to fulfill all the necessary requirements for us to do what we are supposed to be doing. Now, honorable members, we had a meeting on past Wednesday, the 10th of May, where we have received final inputs and amendments or proposals for amendments to the NHI bill. There was an instruction given by myself as the chairperson of this committee to the three groups which constitute the legal services which are supposed to be working on this bill. I will read the specific instruction that I had given. And the instruction was that the Parliamentary Legal Services records, drafts, and presents accurately the amendments that will be proposed by members today. And the department's legal services persons and the state law advisors must also record the amendments proposed and ensure that the A-list drafted by the Parliamentary Legal Services is accurate and drafted correctly before it is presented to us today. Now, in further discussions with the groups as they were doing this work together, I had specifically asked as the chairperson that we have two documents presented today. The one is, the first document would be the instructions given by the committee to the legal services persons. And that document we're going to flight and we're going to go through that document. The second one would be the amendments proposed by the portfolio committee captured correctly in legalese. Now, legalese is the term that is used to explain legal jargon, legal language, etc. We should be reminded that this is towards the end stage where a legal document is being prepared for us to make a decision on, and that will take us further to the next step. So it would mean that it's proper technical legislative sentences which are legally correct and aligned with the rest of the bill. And that would be the second document, which I would then think should be our A-list. Now, I'm going to give each of the three groups of the legal services to give us an indication as to I will then ask that these documents be flighted and presented to the portfolio committee this morning. Thank you. I'll start with the legal services of Parliament.
Good morning, Chairperson and members of the committee. Yes, we met to discuss the amendments as proposed by the committee. I have the A list with the amendments as proposed by the committee, and there is a second document with further amendments that will amplify or to clarify various clauses in the bill. Thank you, Chair.
Thank you very much. I will now go to advocates Joar and Hercules.
Good morning, Chairperson. Good morning, honorable members. Thank you for the opportunity to input into your committee. As a member of the legal team that is responsible for the drafting of this bill, we have met with the department and parliamentary law advisors, and we've collaborated and ensured that the instructions received by the committee on Wednesday is indeed translated into the technical legal language that is required for the A-list to be published and to be inserted as amendments into the bill for the committee. Thank you, Chairperson.
Thank you, Advocate Moabello.
Good morning, honorable members. We have met yesterday as instructed by the committee to carry out the mandate, and we have indeed executed the instruction, the mandate as instructed. We have the document today that we're going to present to the committee for consideration. Thank you, Chair.
Thank you very much for your unselfish work that you had performed. I know it's been a tremendous task. You've done justice, I think, to the process. I forgot about Advocate Achilles.
Good morning, Chair and members. Yes, I confirm my colleagues' input with regard to our involvement with the development of the documents that's going to be presented today. Thank you, Chair.
Thank you very much. So, honorable members, we're going straight to the first document, which will be presented. It will be presented by Ms. Isaac from the Parliamentary Legal Services. They must also give me an indication who is going to present the second document. And just note that you can see that I am rushing considering our time constraints. We will move straight from the one to the other. But before we do, maybe we must just clarify who will be presenting the two documents to us. Ms. Isaac.
Thank you, Chairperson. I am going to speak to the amendments that were proposed by the committee in the meeting of the 10th. I did ask Mr. Hercules to assist with speaking to the schedule as he had drafted that. The second document, I think the state law advisors are going to speak to the further proposals that amplify the current A-list or clarify other clauses. Thank you, Chair.
Thank you very much for that. You would probably highlight your own document. Have you been made a co-host yet, Ms. Isaac?
Yes, Chair, I'm going to do that.
Isaac. Thank you. You may proceed.
Thank you. Chair, if you can confirm that the screen is visible.
Yes, it is. Thank you.
Thank you, Chair. As indicated, these are the list of amendments as proposed by the committee on the meeting of the 10th of May. There's also further technical amendments, which we are mandated to include because once you look to the bill, you will find consequential amendments or certain clauses that need to be tightened up coming from the amendments proposed by the committee. So I'll just point out the further amendments that were not on the list provided to us, but those, as I said, are consequential and technical amendments. So the document that I'm referring to is the draft A-list, and the way it reads is that if members look at the bill that was introduced, the instruction line on the A-list will refer to a page number and a line number. So if you go to that particular page and line number, that particular point of the clause is being amended. So it's a very technical process. So if members look at the bill and the A-list, they will figure out as to what is being inserted where. So I'm going to start with the first clause. And the first clause that amendments were proposed to was the definitions clause. That is clause 1. So the first amendment proposed was on page 5, after line 26, to insert the following definition of basic healthcare services. In the interest of time, I'm not going to read out all the definitions, but it is what was proposed in the committee. So that is basic healthcare services. The second proposed amendment, or the amendment proposed by the committee, is on page 5 after line 48, and we will insert the definition of conditional accreditation. The third proposed amendment was on page 6 in line 8, and to insert the definition of graded certification. On page 4 in line 6, after line 23, the definition of health product is to be inserted. I've highlighted this merely to indicate that this word has now changed to or. It was and or, but the correct drafting would be or. On page, the following two definitions were proposed to be inserted. On page 7, after line 15, to insert the following definitions. The first one being reasonable opportunity, and the second one being reasonable period of time. During our discussions here, we flagged these two definitions as to whether they were necessary to be included, but we will come back to that. The next definition is on page 7 after line 26 to insert the definition of supplier. So Chair, that was clause 1 of the definitions as proposed by the committee on the 10th of May. So I move on to clause 3, and clause 3 deals with the application of the Act. And this particular definition deals with the exemption from the Competition Act. So the amendment is on page 8 in line 5. We are to omit subsection 5 and substitute with the following wording. The fund may be exempt from the provisions of the Competition Act 1998, Act number 89 of 1998, to enable it to fulfill its mandate as a single purchaser and single payer as contained in section 2. This, again, which I've highlighted, is a technical correction from the wording proposed by the committee. It is just the correct drafting there. The next clause is clause 4, which deals with population coverage. The first amendment is on page 8 in line 19 to omit the word migrants and to substitute it with foreigners. And in the clause, the phrase is illegal migrants, and it will now read illegal foreigners. So we're basically substituting migrants for foreigners to correct the terminology. The following amendment is a consequential amendment, which was not in the list provided by members, but it is in line with the proposals. So on page 8, in line 23, to omit registration and to substitute with identity. This is an amendment that is proposed by members in other clauses, but to ensure consistency, it also needs to be done in clause 4. Moving on to clause 5, which deals with registration of users. The first amendment is an amendment we picked up, but it's also a technical issue. So on page 8, in line 55, to omit the word foreign nationals and to substitute with foreigners. This is to ensure consistency with the rest of the wording of the bill. And as I said, it is a consequential technical correction that we are now putting before the committee. The next amendment is on page 9 in line 1. We will omit the word unaccredited and substitute accredited. The following amendment is on page number 3, page 9 in line 4 to omit the word user and substitute person. The two amendments were to correct clause 5.8. There were amendments made to clause 5.8 and we needed to clean it up so it would read better. So number 3 and number 4 are not in the list of amendments proposed by members, but they are technical corrections that we did. So the first one is to omit user and substitute person. On page 9 in line 5, after must, to insert be registered as a user. And the fifth one is on page 9 in line 6 to omit registration and to substitute identity. So that was the amendment proposed by members, and the other two were to ensure that the clause aligned with the amendment proposed by members. We move on to clause 6. Clause 6 deals with rights of users. The first amendment is on page 9 in 911 to omit within the state's available and appropriate resources. The second amendment is on page 9 in line 14 to omit registration and substitute with identity. And that again is a consequential amendment. On number 3 is on page 9 in line 49, after the comma to omit this phrase, any other private health insurance scheme, and to substitute with private insurance covering an international traveler with short-term work or student visa. The next clause we're moving on to is clause 7. Clause 7 deals with healthcare service coverage. On page 10 in line 14, after minister, we will to insert this phrase in consultation with the Minister of Public Service and Administration. And again, Chair, we flagged this particular clause, and that will be considered again later. The next amendment is to clause 8, which clause 8 deals with cost coverage. And the first amendment is on page 11 in line 2, after scheme to insert registered under Medical Scheme Act. Number 2 is on page 11 in line 2 to omit the phrase any other. And on page 11 in line 3 to omit the word scheme and substitute with covering an international traveler with short-term or work visa or out-of-pocket payment. Number 4 is on page 11, line 6 to omit paragraph B. Page number 5 is on page 11 in line 9, after committee to insert or that are not covered by the fund as promulgated in regulations approved by the minister. Number 6 on page 11 in line 10, we omit the word formulary and we substitute with comprehensive set of healthcare services as advised by the Benefits Advisory Committee. So we now move on to clause 11, which deals with powers of the fund. So the further amendments to clause 11 is on page 12 in line 43, after the word from to insert healthcare services. And on page 12 in line 43, after providers to insert health establishment and suppliers. We move on to clause 13, which deals with the constitution and composition of the board. The first amendment is on page 13 in line 32, after the word approval to insert by cabinet. On the second amendment on page 13 in line 43 to omit the and then on page 3, number 3 on page 13 in line 46 to omit the full stop and substitute a semicolon and that is just grammatical correction. And on page 4, the fourth amendment is on page 13 in line 46 to insert the following two new paragraphs. F will read, composition of the board must broadly reflect the diversity of the country, including in relation to age, race, gender, and disability. And G will say, whenever a position on the board becomes vacant before the expiry of the term of office, the minister may appoint any other competent person who meets the criteria listed in Section 13.5 of the Act to serve for the unexpired portion of the term of office of the previous member, irrespective of when the vacancy occurs. Number 5 is on page 13 in line 56 to omit any good cause shown. Number 6 on page 13 in line 57, after the word after to insert inquiry and approval by cabinet. Number 7 on page 14 in line 57 to omit the following two items. There's two clauses there that the members have deleted in their submission. We move on to clause 14, which is chairperson and deputy chairperson. And on the amendment in this clause is on page 14 in line 10 after the word must insert after consultation with cabinet. On page clause 15, we're moving on to clause 15, which deals with functions and powers of board. On page 14 in line 13, we are inserting the sentence, the quorum of the board will be the majority of the total number of board members present, and the board will make binding decisions by the majority of the members present at the meetings, provided that the quorum is attained from the number present. If there is a tie, the chairperson will cast the deciding vote. Again, here, this particular clause is flagged. On page 14, the second amendment to this clause is on page 14 in line 25 to omit the management and administration of the fund, including operational. That phrase is removed. On page 14 in line 26 to omit and practices and substitute with of the fund. On page 14 in line 34, after the word bargaining, to insert employment terms and conditions. And then on page 14, after line 50, to insert the following new subsection, we'll read the board and the CEO of the fund must meet with the Minister and Director General of Health at least twice per year in order to exchange information necessary for the board to carry out its responsibility. We're moving on to clause 16, which deals with conduct and disclosure of interest. And here on page 15 in line 2, after interest to insert or direct a material interest. And I just corrected the drafting there from and or to read or. The next clause we deal with is clause 19, which deals with appointment. And this is under chapter 5, which deals with chief executive officer. So on page 15 in line 22, to omit recommendations in plural and to substitute with the recommendation in singular. On page 15, after line 23, after the word of, to insert the word of approval by cabinet of, that phrasing. And then on page 15, after line 32, after officer, to insert after a fair hearing. We move on to clause 20, responsibilities, that deals with responsibilities of the chief executive officer. And here on page 15 in line 52, to omit the paragraph investigation unit and to substitute with risk management and fraud prevention investigation unit. On page 16 in line 13, to before the word procurement, I should say before procurement, to insert health products. And then on page 16, line 15, after the word risk, to insert the word risk management. So that is just to correct the terms of those committees, the names of those committees. Moving along to page 21, which, clause 21, deals with relationship of chief executive officer and minister, director general, and Office of the Health Standards Compliance. So there's one amendment there on page 16 in line 40 after fund to insert and the board. We move on to clause 23, which is under chapter 6. This deals with committees to be established by the board. And clause 23 itself is titled committees of the board. So on page 17, after line 4, to insert the following subsection. So this is a new subsection which states a member of a committee must A, act in a way that is impartial and without fear, favor, or prejudice. B, not expose himself or herself to any situation in which the risk of a conflict between his or her official responsibilities and private interests may arise, or C, not use his or her position or any information entrusted to him or her for self-enrichment or to improperly benefit any other person.
Ngoba nje akukho pet. Angithi neminyanya ama-pets phela.
Please unmute me. Thank you.
We move on to
honorable members and all other people who have joined our meeting. Thank you.
Chair, we move on to clause 24, which is under chapter 6, which deals with committees to be established by the board, and clause 24 deals with technical committees. So on page 17 in line 16, to omit subsection 4 and substitute with the following subsection, and it's reflecting the same wording as above, so I'm not going to read it again. So this will be the new wording in subsection 4. Clause 25 is under chapter 7, and clause 25 deals with benefits advisory committee. On page 17 in line 35, to omit the word when he or she is no longer a member of the institution that nominated him or her. We are now omitting that phrase. In clause 30, we deal with vacation of office, and the first amendment is on page 18 in line 34. We're omitting the or the second amendment is on page 18 in line 36 to omit the full stop and substitute with a comma and an or. And then the third amendment is on page 18 after line 36 to insert the following new clause, paragraphs. It's D, E, and F. D reads, act in a way that is not impartial and without fear, favor, or prejudice in the interests of specific parties or stakeholders. E, deliberately exposes himself or herself to any situation in which the risk of conflict between his or her official responsibilities and private interests may arise. Or F, make use of his or her position or any information entrusted to him or her for self-enrichment or to improperly benefit any other person. We move on to clause 35, which is in chapter 8, and clause 35 deals with purchasing of healthcare services. On page 19 in line 52, to omit transfer funds and to substitute with reimbursed payments. The second amendment is on page 19 in line 55, to omit transfer to contracting units for primary health care and to insert reimburse directly to accredited and contracted primary health care providers and establishments. In line 20, we're inserting a Roman I after the 8, that is to renumber it. I think this is an error, and then page on number 5, on page 20 after line 3, to insert the following following wording: mobile emergency medical service provider by accredited and contracted private healthcare service providers must be reimbursed on a capped case-based fee service with adjustments made for case severity where necessary. Moving along to clause 37, which deals with contracting units for primary health care. On page 20 in line 13, to omit section 31B of the National Health Act and to substitute with National Health Insurance Act. Number 2 is on page 20 in line 15, to omit manages the provision of primary healthcare service and to substitute with plan for funding of accredited and contracted public and private healthcare providers and establishments. 4 in line 20 to on page 20 in line 18, to delete preferred. The fourth amendment is on page 20 in line 18 after the word unit, to insert through which the fund facilitates development of contracts to be entered into between the fund and the public and private healthcare providers and establishments. 5 on page 20 in line 18, to omit with which the fund contracts. And then on page 20 in line 19, to insert the following, these two new clauses or the units established under subsection 1 must be established to ensure the provision of primary healthcare services, including the prevention, promotion, curative, rehabilitative, ambulatory, home-based care, and community care are directly contracted to by the fund, and the fund must transfer funds directly to PHC providers that have been contracted through to the contracts. A contracting unit for primary healthcare guided by district health resource allocation formula or capitation formulas prescribed by the fund. On the 7th amendment is on clause 20 in line 20 to omit subsection 2 and substitute with the following. Each unit will be responsible for the population in its designated sub-district as determined by regulations and must ensure that the required funding allocation for the capitation and determined and human resources are in place to provide primary healthcare services. Clause 38 deals with Office of Health Procurement, Health Products Procurement. On page 20, line 44, to omit the phrase Office of Healthcare Products Procurement and to substitute with Health Products Procurement Unit. And that is carried through in the next amendments. We do the same on page 20 in line 48, on page 20 in line 52, on page 21 in line 13, on page 21 in line 18. Moving to clause 39, which deals with accreditation of service providers. On page 21, after line 37, after to A to insert a Roman I, that's to renumber the clause, and then on page 21 in line 32nd, after the second, to omit the phrase certification of the Office of Health Standards Compliance and proof of. On page 21 in line 39 to insert Roman II, which will be in possession of and produce proof of certification as graded by the Office of the Health Standards. Clause number 4 is on page 21 in line 14 after criteria to insert accompanied by a budget impact analysis. On page 22 after line 10 to omit for recording of the health patients registration system and substitute with through an information platform as prescribed and accredited by the fund. On number 7 on page 22 in line 26 after law to insert and prescribe in regulations. On page 22 in line 27 after 7 to insert an A, and in page 22 after line 28 to insert the following number B, public health establishment is in undeserved and rural communities must be provided graded certification as provided for by the OHSC with conditional accreditation that is to be prescribed to regulations in clause 55(1)(8). Number 10 is on page 22 in line 34 after B to insert a Roman I, and on page 22 in line 36 to insert the following Roman II, an exception will be made to public health establishment in rural and undeserved areas that have been granted graded conditional accreditation. On page 23, after line 3 to insert E, the duration of the notice must be prescribed in regulation. Moving along to clause 41, which deals with payment of healthcare service providers. On page 23, in line 54, after provider to insert or health establishment providing healthcare services. On page 23, in line 58, to omit must be and to substitute with contracted through. On page 23, in line 59, after care to insert will be reimbursed by the fund through a capitation strategy. Clause 44 deals with appeals tribunal, and on page 24 in line 46 after minister to insert after consultation with cabinet. Number 2 is on page 24 in line 48 to omit board and replace with appeal tribunal. Clause 46 deals with the secretariat, and the first amendment is on page 25 in line 13 to omit board and to substitute with fund. The second amendment is in line 15 to omit board and to substitute with appeal tribunal. Clause 47 deals with procedures and remunerations, and then on page 25, after the full stop, to insert the decision that is being appealed against is suspended pending the outcome of the hearing. We move along to clause 48, which deals with sources of funding, and we in that clause, we on page 25 in line 36, we will omit paragraph B. Clause 49 deals with chief source of income, and the amendment there is on page 25 in line 48, after from to insert national government departments and agencies and. Clause 54 deals with offenses and penalties, and on page 27 in line 13, after discloses to insert confidential. We move on to clause 55, which deals with regulations, and on page 28 in line 17 to omit paragraph U. Second amendment says on page 28 in line 43 to omit subsection 4. Clause 57 deals with transitional arrangements. So on page 28 in line 57 to omit 1 and substitute with 2. The second amendment is on page 28 in line 57 to omit for a period of 5 years from and to substitute with between. Number 3 is on page 28 in line 57 to omit 2022, which must and substitute with 2023 and focused on. That's the phrasing that will be inserted. On page 29 in line 11 to omit 2022 to 2026 and replace with 2023 to 2027 and be aligned with progressive realization of UHC goals. On page 29 in line 15 to omit and on page 29 in line 16 to insert Roman 4, preparation for the establishment of the fund as a Schedule 3A entity contemplated in section 9. The minister must, in consultation with the Minister of Public Service and Administration, and establish an appropriate administration capacity to develop and prepare the functions of the fund. Chairperson, can I hand over to my colleague to take us through the schedule?
Thank you. So, thank you.
Mr. Hercules.
Thank you, Ms. Isaac. So actually we're going to have, so you talk, when you said schedule, you mean this one, and I'm certain that in the A list, the schedule would also be contained in this. So we'll have then 4 minutes of presentation. But before he does this, I picked up two lines which you could possibly have omitted, Ms. Isaac. The one is clause A to B of page 11 of the NHI bill, which you had not read. It's point 4 on your document. If you can maybe go back there. You probably just skipped it over in the reading. Point 4. Which speaks about clause A to B. Yes. So on page 11, that one you had just accidentally skipped over. So maybe if you
my
could.
apologies. My apologies. To omit paragraph B.
Yes, thank you. And the second one is on clause 35A1. Which speaks to amendments to proposed addition of facility-based emergency medical services. (35A1). So that you also did not mention that one, which speaks to proposed addition of facility-based emergency medical services. I need to be assisted here. If it is not here, I will ask advocates, the other three advocates, maybe just to assist.
Chairperson, if I may.
Yes, thank you.
The clause that you referred into is cost coverage clause 8, subclause 2, paragraph B, and the committee had instructed that the failure to comply with referral pathways prescribed by a healthcare service provider or health establishment be completely deleted as a bar to accessing services by a user of the NHI. I'm able to confirm that we have indeed deleted that and deleted it in its entirety, and additional grounds or the reaffirmed clear grounds that has been instructed by the ANC has been captured, Chairperson.
Thank you. And on the, is that, and on the second one I mentioned? I am struggling to hear you a little bit, Advocate Joa, so I'm not sure. Did you speak to now to clause 35A1?
35A1, I spoke to clause 8, and on 35A1, 35.1,
35.1.
35.1, 2 and 3, I'm able to confirm, Chairperson, that the legal team did capture the substitution for the transferring of funds to reimbursement, and we make it clear that the fund now directly reimburses accredited and contracted primary healthcare providers and health establishments. Yes, Chairperson.
Yes, and the amendments to propose additional facility-based emergency medical services.
Yes, yes, Chairperson.
All right, thank you. I will now hand to Advocate Hercules to continue with the schedules.
Thank you, Chair. May I just ask Ms. Isaacs just to move the text as I speak to the items listed on the schedule. Chair, with regard to the schedule, the legal team considered the amendments proposed by the members of the committee, as well as the department's input. And we've also included, as a result thereof, certain technical and drafting corrections, which forms part of the list that I will speak to now. Chair, the amendments to the schedule is found from page 31 in the bill, and you will note from the bill the list of amendments of certain legislation listed there are contained 3 columns. The one column relates to the Number and Year Act, the other one the short title of the Act, and the other one the extent of the repeal or amendment. So as I speak to the items listed here on the document, it will refer to a page, a line number, and also the column number. Chair, on item 1, it relates to the item 1 to 3 actually relates to the Medicines and Related Substances Act 101 of 1965. Chair, the first amendment is item 1. It's on page 31. In the second line of the second column, it's to omit control. We noted that that was an error in respect of the title of the act. Previously, as it is now, it reads Medicines and Related Substances Control Act. The word control must be deleted. So here we omit the word control in item 1. Item 2, on page 31, from the 4th line of the 3rd column, to omit the words in consultation with the Office of the Health Products Procurement established in section 38 of the National Health Insurance Act 2019, and to substitute with the words after consultation with the National Health Insurance Fund, established by Section 9 of the National Insurance Act 2019. So this amendment basically reflects the party to be consulted in view of the input that we received for an amendment. As a result, there's also a consequential amendment in item 3 on page 31 from the 14th line of the third column to omit paragraph B. Chair, the next amendment relates to amendments on item 4 and 5 relates to the Health Professions Act, number 56 of 1974. In this amendment, in 4 and 5, we're fixing the wording of section 53(1)(b). It's basically just a technical drafting correction, the way the words were structured. So the words basically still remain there as we have it, but it's just structured below paragraph B of subsection 1 in the text of the section. So item 4 on page 32 in the 26th line of the third column to omit the words "and shall in a case 2", and then we correct it under item 5 on page 32 in the 27th line of the third column before to insert the words before which to insert the words "and shall in a case 2". So there we're just fixing the alignment of those particular words in that section. Chair, item 6 to 8 refers to the amendments to the Allied Health Professions Act, number 63 of 1982. And it relates firstly to item 6 relates to the amendment to section 38 capital A1. And here in this this amendment, we are just you will note from text it refers to the masculine form, and we just fixing the gender references there. So on page item 6 on page 33 in the 19th and 24th lines of the third column, after him to insert "or she". And then item 7 relates to the amendments to the Compensation for Occupational Injuries and Diseases Act, Act number 130 of 1993. And Chair, this is also, the bill has been introduced since 2019. So a number of these acts have been amended, and this is one of the acts that have been amended by an Amendment Act 10 of 2022. And as a result of that, we no longer require the definition, an amendment to the definition of compensation. So in item 7 on page 33, from the 29th line of the third column to omit paragraph A. And item 8 on page 33 from the 49th line of the third column to omit item 3. Item 9 relates to the amendments to the Competition Act 89 of 1998. On page 35 in the fourth line of column 3, after services, to insert the word "and". That is just a drafting correction to make provision of a paragraph C to follow after that amendment in the text. Item 10 relates to the amendments to the Correctional Services Act 111 of 1998. Item 10 on page 35 from the 21st line of column 3 to omit subsection 3 and to substitute the following section. 3, every inmate may be visited and examined by, and we delete the words, a medical practitioner of his or her choice, and we insert the words, an accredited healthcare service provider, subject to permission of the head of the correctional center, and we delete the remainder of the words in that provision, may be treated by such practitioner, in which event the inmate is personally liable for the cost of any such consultation, examination, service, or treatment. So basically, the amendment is to ensure that it's aligned with the content or with the provisions of the bill regarding coverage for inmates. The item 11 relates to the amendment to the Medical Schemes Act 131 of 1998. We noted that that the Act does not provide for a definition of the Public Finance Management Act. And in that regard, we need to make full reference to the year and number of the Act. So item 11 reads as follows. On page 37, in the fourth line of column 3, after Act to insert, comma, 1999, Act number 1 of 1999, close the brackets. So that is to give effect to the correct citation of the Public Finance Management Act. Item 2 relates to amendments to the National Health Act 61 of 2003. And item 12 specifically relates to section 31.3. Item 12 on page 38, after second line of column 3, to insert E by the insertion in subsection 2 after paragraph L of the following paragraphs. So basically, we noted that the instructing formulation for the amendment was not listed there. It was probably an error. So we're just fixing the error there to ensure that the paragraph following after paragraph 11 is then introduced. And as a result of that, we had to fix the numbering of the paragraphs in the column. So item 13 on page 39 in the first line of column 3 to omit E in brackets and to substitute F. Item 14, because there's a paragraph C in section 31.3 of the Act, so we need to make provision for to address the drafting correction there. On page 40, in the 21st line of column 3, to omit the full stop and to substitute semicolon and to be underlined because it will be inserted in that provision. Then we're under item 15, there's a grammatical correction with regard to the reference to subparagraph. It should be in the plural form, subparagraph. So on page 41, in the 28th line of column 3, to omit the word subparagraph and to substitute the word subparagraphs. Item 16, Chair, in respect of the amendments that were presented by the members of the committee with regard to the deletion of section 31B that was inserted in the National Health Act. Section 31B provided for the establishment of contracting units for primary health care. That is now dealt with under clause 37 of the bill. So as a result, we have effected the amendment on page 43 from the first line to omit section 31B, since it's dealt with now in the main provision of the bill, more specifically clause 37. Item 17 to 20 deals with the amendments to the Prevention of and Treatment for Substance Abuse Act, number 70 of 2008, more specifically section 7 of that act. The first amendment is under 17 on page 44 from the 32nd to 33rd line of the third column to omit the words Office of Health Products Procurement and to substitute Health Products Procurement Unit. So it's basically to align it with the content of the bill. Item 18 on page 44, in the 48th line of the third column, after the word abuse, to insert and to underline and. It's just a drafting correction, the same with item 19. On page 44, in the 52nd line of the third column, after the word abuse, to substitute semicolon with a full stop. This is basically this is actually basically to give effect to the deletion of the paragraphs C and D. And item 20 basically is just to fix it's just a drafting correction there to include paragraph D. So on page 44, after the 57th line of the third column, to insert open brackets D, close bracket, provide assistance to persons who establish substance abuse services. So that particular paragraph was omitted, it was cut off, and we are just inserting it back. So it must also be part of the deletion in respect of section 7(1), paragraph D of that provision of that act. Chair, those are the amendments on the schedule of the bill. Thank you, Chair.
Thank you very much, Advocate. I just want to make certain of one other clause, clause 2B, which I think would have been omitted could not have been deleted, which we had suggested to be deleted. So I don't have any points to raise on the schedules now. We will take any discussions later, honorable members. So I just want to go back to clause 2B. Which read ensuring the sustainability of funding of healthcare services within the Republic. If I remember correctly, we had suggested that it be deleted. Anyone wishes to?
Chairperson, I'm just looking at the. Sorry, Chair. It's Suanne. I'm just looking at the document that we received from the committee, and it isn't a 2B listed as one of the amendments that we needed to consider.
Okay, so maybe it's A2B, which I already raised earlier. Okay. All right, we will now move on to Advocate Joar. The next step of our work, honorable members, is now to have the entire A list presented. Thank you very much, Advocates Isaac and Hercules, for the work done and the presentations made. Honorable members, we are on to the actual list as I had indicated that would have been redrafted as an entire list, considering the legal language it is needed to be used and the technical legislative sentences which are legally correct and aligned with the rest of the bill. I will hand over to Advocate Joar.
Thank you, Chairperson. If I may, one of my other colleagues that was in the meeting yesterday to flight the documents so that I could use my hard copies and somebody else moves the electronic copy, please. Yeah. Okay, it's fine. If there's nobody that's
I'm
volunteer-
looking for the sharing icon. Can they give me permission to share?
Okay, thank you so much, sir.
Can the host give me permission to share the document?
Ms. Majalamba, who is hosting us? Ms. Majalamba, can you give sharing rights to Advocate Mabelo? Or Ms. Ngumane?
Yes, I'm doing that, Chair. I don't know what is
Thank you.
happening here. Mm. Mm. Conference, yes.
Advocate Mabelo, I see you already received the rights. Can you please flight the document and let us proceed? Advocate Mabelo?
Thank you so much, Chairperson. Honorable members, good morning. Thank you for allowing us the opportunity to present the work of the three sets of lawyers who you've tasked to ensure that the bill is properly drafted in the form and style that conforms to best practice worldwide, as well as to ensure that the alignment of the instructions received by the Portfolio Committee is correctly and accurately reflected in the text of the National Health Insurance Bill, Bill 11 of 2019. So if we were to commence with clause 1, our first instruction from the Portfolio Committee was to insert the definition of basic health services, which we have done so as item 1 of clause 1. Moving on to item 2, you would notice that an attempt is made to omit the words pre-hospital on page 6 in line 2. What this in effect is the culmination of an exercise we embarked on with the basic healthcare services insertion. We ensured that the different levels of services that is contemplated in the bill and defined in the bill. Here specifically, I'm talking to the definition of comprehensive healthcare services, healthcare service, basic healthcare service, and emergency medical service. We needed to ensure as a legal team that the cascading of services and the baskets of services that are contemplated and provided for in the Act are indeed accurately reflected and capable of implementation. We had then sought to, given the insertion of a new definition of basic healthcare services, to broaden the definition, or in fact, broaden the basket of services that falls under or falls within the ambit of emergency medical services by not limiting it to the offering of only pre-hospital acute medical treatment. With the deletion of pre-hospital, it now renders emergency medical services to be services provided by any private or public entity, dedicated, staffed, and equipped to offer acute medical treatment and transport of the ill or injured. That means that whether your pre-hospital, whether your acute medical treatment is received before you are admitted to a hospital or even a clinic, it is now accommodated under emergency medical service. We have included and redrafted very technical exercise that I won't bore you with, but we have included the definition of health product, and we assure the committee that the draft is sound and accurate. There were two definitions instructed to be inserted in the bill. The one is conditional accreditation, and the second is graded accreditation. On these specific definitions, the rules of legislative drafting provides that a definition never deals with the substantive content of what is being defined. And as a team, we had felt that the conditional accreditation would be better provided for not a definition, but rather as a substantive provision in the body of the National Health Insurance Act. And when we get to clause 39 sub 12 later, we'll be able to demonstrate that the content of both conditional accreditation and what is intended with graded accreditation is contained in that clause. We've also been asked to insert the definitions of reasonable opportunity and reasonable period of time. When we considered the definitions that were provided to us, as the legal team, we were apprehensive to insert those definitions in light of the fact that the idea and the term, the specific reference, reasonable, has developed over a number of years in our courts. And we've arrived at a point where reasonable is legally defined, not expressly in an instrument, but jurisprudentially. The idea of reasonable is settled and will be applied whenever the legal instrument requires an interpretation of reasonable to be provided. Generally, when reasonable is required to be interpreted, what users of the legislation is meant to do is to take into account, and certainly a court will take into account, the circumstances that prevail in that specific matter, and reasonable may differ from case to case. So therefore, it will be decided on a case-by-case matter, taking into account the specific circumstances that prevail at that time. Given that is where we find ourselves legally, we would prefer, and we would ask the committee's indulgence, to not include the definitions of reasonable, both opportunity and reasonable period of time in the book. We have included the definition of supplier as requested. On item 3, you will see that on page 7928 of the minister, we've inserted and directive issued by the fund. This really is an amendment to the definition of this act. Now, when we define this act, what we're doing is that everything that is named and included in the definition of this act gets elevated and enjoys the status of law. But what we have noticed is that within the body of the bill, we authorize directives to be issued by the fund and not by the minister, him or herself. So what we've now done is to correct the technical error that appears in the definition of this act to now read, this act includes any regulation promulgated by the minister or directive or rule made or notice issued by the fund in terms of this act. It's now technically legally correct. Wherever we find the word directive, this act defines it as a directive as issued by the fund, but where we make references to prescribed or as prescribed or regulation, we know that it is the instrument that is promulgated by the minister. On clause 3, we have, as instructed by the committee, exempted the fund from the Competition Act, and we redrafted the wording to conform with the rules of legislative practice. It now reads that the fund is exempt from the Competition Act to enable it to fulfill its mandate as a single purchaser and single payer as contemplated in Section 2. Section 2 here being Section 2 of the National Health Insurance Act after enactment. In clause 4, we have rectified the incorrect reference to migrants, and we have inserted the reference to foreigners. The reason why we've used foreigners both in clause 4 and clause 5 is because we have searched our statute books and found that foreigners is the exact defined term used in the Immigration Act. And by using the word foreigners in the National Health Insurance Act, whoever requires a definition of foreigners would be sent to the Immigration Act and find its definition there. So we satisfy, Chairperson, that foreigners as contemplated in the National Health Insurance law is identical to the defined term foreigners in the Immigration Act. Please excuse the spelling error. In item 1, clause 4, it will be fixed before the bill gets sent for printing. On page 9 in line 5, I'm on page 3. On page 9 in line 5, we have redrafted the instruction of the portfolio committee to deal with the intention that wherever reference to proof of registration is made, that it is replaced with proof of identity. Not highlighted to us by the portfolio committee, but as a result of the search that we conducted, we had found that in clause 4, subclause 4, the term appears, and it's required redrafting to accommodate proof of identity. The clause will now read, a person seeking healthcare services from an accredited healthcare service provider or health establishment must be registered as a user, of the fund from an accredited healthcare service provider. No, let me start again. A person seeking healthcare services purchased for his or her benefit by the fund from an accredited healthcare service provider or health establishment must present proof of identity to that healthcare service provider or health establishment when seeking those healthcare services. Moving on to clause 6, paragraph O, we have redrafted the paragraph to reflect the instruction of the portfolio committee. It will now read, to purchase healthcare services that are not covered by the fund through a complementary voluntary medical insurance scheme registered in terms of the Medical Schemes Act, any other private health insurance scheme is deleted, and in its place it will be private insurance covering an international traveler with a short-term work or student visa or out-of-pocket payments, as the case may be. This dovetails with the previous clause, clause 4, sub 5, where we provide that the expectation and the obligation certainly is that when a foreigner visits the Republic for any purpose, that foreigner must have private travel insurance, and where the person does not have private medical insurance, he or she becomes subject to what is granted in terms of the national health insurance. On clause 7, to ensure that the instruction of the committee is given effect to, and to ensure that the instruction is indeed aligned with all other acts that are involved and have bearing, we have substituted the clauses that deals with the establishment of central hospitals. Firstly, to comply legally. Secondly, to technically be drafted correctly. And thirdly, also to provide an option for a scenario where it's not viable to designate every central hospital as a national government component, where there is enough flexibility to decide on a case-by-case basis the appropriate levels of autonomy that ought to be granted to central hospitals. We have now redrafted the clause to read: the minister, and this is the Minister of Health, must request the Minister of Public Service and Administration to consider and assist the establishment of central hospitals as national government components in accordance with Section 7.5 of the Public Service Act. Where central hospitals are not established as national government components, the minister must establish or designate central hospitals as an organ of state in an appropriate form. On clause 8, and Chairperson, I'd like to draw your attention specifically to this clause, because you had asked the parliamentary law advisor for the clause. Clause 8 deals with cost coverage, and we've amended sub-clause 2 to reflect the instruction of the committee. We have deleted the paragraph that read, fails to comply with the referral pathways prescribed by a healthcare service provider or health establishment. What it now means is that a personal user must pay for healthcare services rendered directly or through a voluntary medical insurance scheme if that personal user, A, is not entitled to healthcare services purchased by the fund in terms of the provisions of the Act, seeks services that are not deemed medically necessary by the Benefits Advisory Committee, seeks services that are not covered by the fund as prescribed, or seeks services that is not included in the comprehensive set of healthcare services as advised by the Benefits Advisory Committee. It thus results in a scenario where failure to comply with the referral pathways is not an automatic bar by any user or person to access healthcare services that may be required. Chairperson, if I may move on to clause 11. The bill currently reads that only providers are obliged to share data for use by the National Health Insurance Fund. This was firstly legally uncertain and ambiguous, and secondly, on instruction of your portfolio committee chairperson, we have expanded and clarified exactly who is obliged to provide information, and it now will read, and this chairperson is clause 11, subclause 1, paragraph I, Roman numeral 4, and it talks to powers of the fund. And the fund may, and it's an authorization to the fund may identify, develop, promote, and facilitate the implementation of best practices in respect of receiving and collating all required data from specifically healthcare service providers, health establishment, and its suppliers for the efficient running of the fund. So we've now identified 3 very specific groups that are expressly provided for in the law who will be required to provide information to the fund. In clause 13, we have implemented the committee's instructions, and 13 sub 1 will now read, the board consists of not more than 11 persons, and here's an insertion, who broadly reflect the diversity of the Republic, including in relation to age, race, gender, and disability, appointed by the minister who are not employed by the fund, and 1 member who represents the minister. We've inserted throughout the bill and wherever indicated by the portfolio committee that under certain circumstances and before certain decisions and actions are taken, that the approval by cabinet ought to be sought. So in clause 13, specifically, we insert the approval by cabinet when the ad hoc advisory panel is appointed by the minister, and so on and so forth. And throughout the bill, there are dotted insertions where approval of cabinet must be sought. In clause 13, Chairperson, in a very technical exercise, we have, in order to accommodate and insert the instructions of the portfolio committee, we have redrafted a new, the sub-clause 9 of clause 13 to now read, the minister may dissolve the board only after an inquiry is conducted into the board and cabinet approves the dissolution. When a vacancy occurs or the board is dissolved at any time before the expiry of the term of office of that member or the board in its entirety, the minister, A, may appoint acting board members for a maximum period of 3 months to carry out the functions of a board member, subject to any conditions that the minister may require, and B, must, as soon as practicable, but not later than 3 months from the day the vacancy occurs or the board is dissolved, appoint a member of the board or a board in the manner contemplated in this section. So again, the appointment procedures for the board and the members of the board would be applicable upon a vacancy occurring or the dissolution of the board, should that happen. I'd like to move on to clause 15, Chairperson, to indicate that the amendment that was effected to the clause ensures, as far as possible and as far as is the norm, that the board is divested from as many operational matters as possible. And on instruction of the portfolio committee, we had substituted clause 15, subclause 3, paragraph A, with the phrase, the financial and administrative policies of the fund. The effect of that is now the board must advise the minister on any matter concerning only the financial and administrative policies, no longer operational policies and practices. As asked for by the committee, we have inserted a new subclause 5 that reads, the board and the chief executive officer of the fund must meet with the minister and the director general of the department at least twice a year in order to exchange information necessary for the board to carry out its responsibilities. The committee had asked us to expand the definition, of financial interests to include both direct material interests as well as indirect. We have done so. In clause 16, subclause 3, which will now read, for purposes of subsection 2B, a financial interest means a direct and or indirect material interest of a monetary nature or to which a monetary value may be attributed. That definition is necessary for purposes of applying clause 16 2B, which is the obligation that a member of the board may not attend, participate in, vote, or influence the proceedings during a meeting of the board or of a committee thereof, if in relation to the matter before the board or committee, that member has an interest, including a financial interest, which then further we know to mean a direct or indirect material interest of a monetary nature that precludes him or her from acting in a fair, unbiased, and proper manner. The effect of this, chairperson, is that the bar essentially has been lifted that must be met by a member of a board in any matter before it is being considered. Again, chairperson, as we did in clause 15, clause 16 has the insertion. Sorry about that. I'm just on clause 17, also in the vein of governance arrangements, the committee had instructed that the bill must expressly provide for what is required for a quorum to be attained and how decisions of the board must be taken. We've inserted the instruction of the committee into clause 17, which is a part of the chapter that deals with the operational matters concerning the board. And clause 17 will now read quorum, decisions and procedures, and it provides that a majority of all the members of the board constitutes a quorum for a meeting of the board. Any matter before the board is decided by the votes of the majority of the members present at the meeting, provided that the members present constitute a quorum for a meeting of the board, and the member presiding at the meeting must exercise a casting vote in addition to that member's vote as a member, if there is an equality of votes. And then, as contained, we go on to read, the board must determine its own procedures in consultation with the minister. In clause 19, chairperson, I'm embarrassed to say that there was a spelling error in line 22 that has now been fixed, as indicated previously, where the approval of cabinet has been instructed, we've inserted it. And in the amended clause 19 sub 5, we've made sure that principles of natural justice are included in the bill. And 5 will now read, the board may recommend to the minister the removal of the chief executive officer after a fair hearing, if that person, and then a paragraph A, B, and C follows. So there's an express reference to the principles of natural justice being afforded to a CEO when there is arrangements taking place for his or her removal. Moving on to clause 20, the committee had indicated that there are numerous units and numerous names of units that are reflected in the bill, and that these must be aligned and it must be provided for better. We've done so, chairperson, in clause 20. We have in subclause 22, paragraph E, substituted investigating unit with the risk management and fraud prevention investigation unit, which is provided for later on page 16, also in subclause 3 of the bill. The procurement procurement unit contemplated. We've made sure that the procurement unit referred to in this clause is also the procurement unit that occurs later on in the bill. Moving on, Chairperson, to clause 20, where am I? Still on clause 20, we have on page 15 after line 48 inserted the following paragraphs as responsibilities of the CEO. The committee had instructed that we deal with specifically and provide specifically for terms and conditions of employment of fund employees and collective bargaining to be inserted, but to be moved. And we've now placed it in clause 20. The clause will now read, subject to the direction of the board, the responsibilities of the chief executive officer include the terms and conditions of employment of fund employees and collective bargaining. Chairperson, we as a legal team are comfortable that terms and conditions of employment and collective bargaining fall squarely within the ambit of the responsibilities of a CEO. And we're happy, Chairperson, that it's now been inserted in that section. In clause 23, under the committees of established by the board, the committee had instructed that we provide more expressly for behavior and the manner of conduct. And we have inserted on your instruction a subclause 5 to clause 23 that reads, a member of a committee contemplated in subsection 1 must act in a way that is impartial and without fear, favor, or prejudice, not expose himself or herself to any situation in which the risk of a conflict between his or her official responsibilities and private interests may arise, or C, not use his or her position or any information entrusted to him or her for self-enrichment or to improperly benefit any other person. This, Chairperson, I must indicate the legal team had thought was a valuable and welcomed insertion into the bill by the committee. And we've ensured that not only will it apply in clause 23, where generally committees of the board are discussed and provided for, but also it applies to every committee established by the board, every technical committee provided for in the bill, as well as other committees contemplated in this act. So we've made sure that there is consistency throughout the NHI bill, that where we talk of committees, we expressly provide for the level and the standard of behavior or conduct that will be required of these individuals. Move on to clause 28. The original clause in the NHI bill talks about disclosure of interests, and as instructed, the committee wanted the conduct of members of committees to be good conduct at all times. We've now inserted this standard also in the chapter that deals with advisory committees established by the minister. You'll recall, Chairperson, that we're talking about the Benefits Advisory Committee, the Pricing Committee, the Stakeholder Advisory Committee, and so forth, and so on and so forth. So instead of just providing for disclosure of interests, we also provided now for the conduct that is expected and obliged or obligated by them. And it is the same standard of conduct that is required in other committees as well. So there's consistency. Again, this is the consistency that I was talking about earlier that is now effective throughout the bill. Moving on to clause 35. This clause deals with the purchasing of healthcare services, and Chair, it's the clause that you were looking for, and you wanted confirmation that it has indeed been amended, and I'm able to confirm that 35.2 will now read: the fund must reimburse payment directly to accredited and contracted central, provincial, regional, specialized, and district hospitals based on a global budget or diagnosis-related groups. And it will go on to read: funds for primary healthcare services must be reimbursed directly to accredited and contracted primary healthcare providers and health establishments, healthcare establishments at the sub-district level as outlined in section 37. 4 is the exact reference you were looking for, and it provides facility-based emergency medical services provided by accredited and contracted public and private healthcare service providers must be reimbursed on a capped case-based fee basis with adjustments made for case severity where necessary. We've also, Chairperson, upon your committee's instruction, inserted a paragraph that will read: mobile emergency medical services provided by accredited and contracted private healthcare service providers must be reimbursed on a capped case-based fee basis with adjustments made for case severity where necessary. Again, this is consistent with paragraph A above, but it deals with a different form of emergency medical service that is provided. The contracting unit for primary health, the instructions of the committee was effected. We have, rather than, as instructed, rather than to provide for the establishment of the contracting units in the National Health Act, it is the National Health Insurance Act that will provide for the establishment of these units. 37.1 now reads: a contracting unit for primary health care is hereby established. In order for us to ensure that there is some flexibility or some room for the contracting units to be, functions to be expanded whenever necessary, we have thought it appropriate and technically and legally sound to ensure that the functions that are listed in subclause 2 of clause 37 is not interpreted to be a closed list. We have, in order to ensure that, inserted the word amongst others before the list of functions that we are expressly provided for is named. The clause will now read: a contracting unit for primary health care must be comprised of a district hospital, clinics or community health centers, and ward-based outreach teams and private providers organized in horizontal networks within a specified geographical sub-district area, and must assist the Fund 2, amongst others. And then we list the functions that will be assigned to the contracting unit for primary health care. On instruction of the committee and incidentally on the advice of the DPSA as well, we have refrained from employing the term office in naming of units that are established under the NHI, and wherever the reference and the name Office of Health Products Procurement occurs, we have substituted it with Health Products Procurement Unit as instructed by your chair. Moving on to clause 39. This clause deals with the accreditation of service providers, and we have, as instructed, amended the sub 2 to read, in order to be accredited by the fund, a healthcare service provider or health establishment, as the case may be, must be in possession, this is paragraph A, be in possession of and produce proof of registration by a recognized statutory health professional council. We have inserted a new B to read, be in possession of and produce proof of certification by the Office of Health Standards Compliance, and C, meet the needs of users and ensure service provider compliance with prescribed specific performance criteria, accompanied by a budget impact analysis, including, and we list more than 5 items that must be included. We have, as asked for by the committee, we have removed a reference to patient health registration system and have instead made it more generic to read, in order to be accredited and reimbursed by the fund, a healthcare service provider or health establishment must submit information to the fund through the prescribed information platform. So we're not naming the platform that is contemplated in the Act, only to say that it will be compulsory, even that it will be prescribed for all accredited healthcare service providers and health establishment to feed into and to utilize this information platform so that the NHI could operate effectively and efficiently. Goodness. Chairperson, I would like to move to subclause 9. So it's accreditation, clause 39, subclause 9. We have amended this clause to ensure that it is improved from a legal process and natural justice principle perspective. And it now reads, if the fund intends to withdraw the accreditation of a healthcare service provider or health establishment, or intends to refuse to renew the accreditation of a healthcare service provider or health establishment, the fund must provide a healthcare service provider or health establishment with notice of its intention, provide a healthcare service provider or health establishment with a reasonable opportunity to make representations in respect of such intention, consider the representations made in respect of paragraph B, provide adequate reason for the decision to withdraw or refuse the renewal of accreditation to a healthcare service provider or health establishment, as the case may be. The provisions of this new amended 9 now accurately mirrors the sequence of events that will take place before an ultimate decision is taken by the administrator, in this case the fund, to withdraw or not to renew accreditation of some service provider or establishment that prior to this decision was in possession of a valid accreditation. It then means that after the intention of the fund is made known, those who are going to possibly be negatively affected by that intention, and in accordance with the Promotion of Administrative Justice Act and the principles of natural justice, that person or establishment or person representing the establishment is indeed being notified that this may happen, being given an opportunity to make representation, is ensured an opportunity to be heard, and after, should an adverse decision be taken by the fund, that reasons for that decision is provided to the person affected. We are also in the bill already providing that an appeal may be lodged against this decision. But more than that, Chairperson, we have in 11 enhanced the clause to ensure that directives are issued by the fund that talks to the possible myriad of consequences that could be the result of a decision to not renew or to withdraw. This includes a scenario where practically, let's say, one of the grounds that accreditation is withdrawn of a health establishment may be that deaths, unexplained deaths are occurring at the establishment. We then require on a very practical level to provide notice to that establishment that your practice is, your accreditation to practice or to run this establishment is withdrawn and we require you to shut down. But it may be that we require the establishment to be shut down immediately, or in another scenario where it isn't death that we're dealing with, but it's some other occurrence that causes the withdrawal or the non-renewal, where we may want to allow a certain amount of time to the individual or to the establishment to organize themselves, maybe inform their patients that the practice is going to close, etc., etc. Because we are unable at this very moment and possibly will not ever be able to cater for every possible scenario that may arise, we have inserted into 11 the following, and 11 will now read: the fund may issue directives relating to the listing and publication of accredited healthcare service providers and health establishments, and the periods applicable to healthcare service providers and health establishment where accreditation is withdrawn, not renewed, or appealed. This is important because we later on in the bill provide that where you appeal a decision by the fund, that decision is suspended until the finalization of the appeal itself. So that means that already we have one scenario where a directive must indicate to affected persons that though your accreditation has been withdrawn, hold on for a minute, this isn't a final decision. The outcome of the appeal will dictate what is to finally happen. Then we've inserted, Chairperson, a new 12 that indicates that, and this is where I referred you to when we were dealing with graded certification, accreditation, and conditional accreditation. Rather than dealing with it substantively in definitions, we have substantively inserted it into the body of the bill, and it will read: the fund may grant conditional accreditation to a healthcare service provider or health establishment as prescribed by the Minister after consultation with the Office of Health Standards Compliance. The intention here, Chairperson, is to ensure that the conditional accreditation, the idea of issuing a conditional accreditation, is authorized by this law, and that the Minister is authorized to promulgate regulations that are required for us to implement the concept of conditional accreditation. In clause 41, we have amended the payments clause 41.3 specifically to make it clear that an accredited primary healthcare service provider or health establishment providing primary healthcare services must be reimbursed by the fund in accordance with the prescribed capitation strategy. So essentially what this means is that healthcare establishments and healthcare service providers would provide services, and those services will be reimbursed directly by the fund and not other entities or units that is created in the ambit of the national health insurance environment. We have ensured in clause 44 that when the appeal tribunal is appointed by the minister, they are appointed after consultation with the cabinet as instructed by the committee. And in that clause, in a number of clauses which follow, there are a number of errors that we have rectified. And by way of example, I point out that in clause 44 on page 24 in 948, board was incorrectly used in the clause when it should have been reference to appeal tribunal. In clause 47, in response to the instructions of the portfolio committee, we have indeed halved the time that was granted to the appeal tribunal to finalize their matters. Rather than having 180 days to finalize an appeal, they now will have only 90 days at their disposal to finalize their matters. The committee had asked us to expressly include into the bill a provision that reads, the operation and execution of a decision which is the subject of an appeal is suspended pending the decision of the appeal. This in ordinary parlance then means that where a decision is being appealed, we expressly provide that you need not do what the decision required of you until such time as the appeal tribunal either confirms, substitutes, or removes that decision in its entirety. So that, as you wanted, portfolio committee, is contained in clause 47. As instructed in clause 48, we have removed fines in its entirety as a source of funding for the NHI. And in 49, in a related provision that deals with the chief sources of income, we have expanded the pool of sources of income, and the bill will now read the money referred to in subsection 1, which is the money that is appropriated by Parliament annually to the National Health Insurance. The money referred to in subsection 1 must be appropriated from money collected and in accordance with social solidarity in respect of general tax revenue, including the shifting of funds from national government departments and aid agencies and provincial equitable share and conditional grants into the fund. In clause 54, we have double-checked the Promotion of Access to Information Act as well as the Protection of Personal Information Act, and given effect to the instruction of the Portfolio Committee to ensure that the offences and penalties that are created relates only to the selling or other form of disclosure of confidential information, not just ordinary information that is owned by the fund, but it's specifically the confidential information that is owned by the fund that, if and when sold or disclosed, may amount to an offense and attract a penalty. In clause 55, we have authorized the minister to promulgate regulations, both in respect of accreditation, which already exists, as well as conditional accreditation, the concept which is now new to the bill, but inserted rather expressly. We have omitted paragraph U and subsection 4 in clause 55 as instructed by the committee. If we could move on to clause 57, here to the transitional arrangements, you and your members, Chairperson, have asked for an amendment to rectify the time periods provided for, given that phase 1's time period has already expired, and we have amended the time periods and redrafted it as a result of the time periods that were now falling into the area of inoperability and impossibility. Phase 1 will now run from 2023 to 2026, and phase 2 will run from 2026 to 2028. And then finally, Chairperson, we have inserted into the bill a clause, as you requested, that authorizes that work must be done as soon as the National Health Insurance Bill is enacted and signed by the President. That work must be done to ensure that the fund is established as a Schedule 3A entity as soon as possible. Now, this insertion dovetails with the provision in the earlier clauses of the bill that provides that this is the form of organization that the fund will have to take, but we're making sure that as soon as the bill becomes law, that work commences to prepare for the establishment of the fund as a Schedule 3 capital A entity. Chairperson, what follows over the next 2 pages are the amendments of the to the schedule of the National Health Insurance Bill. I'm able to confirm that you and your members have heard presentation by my colleague, Mr. Hercules, and that these provisions on page 13, 14, and 15 are identical to the ones that was presented by him. And then finally, as a result of the changes made, amendments to the table of contents or arrangements of sections will be required, and we have inserted these necessary provisions into the bill on its very last page. So you will recall, Chairperson, that we redrafted the clause that deals with decisions to accommodate also quorum and decisions, and we've inserted conflict and standards of behavior, and we've changed the name of Office of the Health Products Procurement to Health Products Procurement Unit, and these must be amended in the table of contents as well. Thank you, Chairperson.
Thank you very much, Advocate Johan. Let me take this opportunity to thank all 3 group legal advisors for a sterling job. We really appreciate you way into the late afternoon and early evening to finish this work, and that you're able to come and present it to us this morning. I want to ask the 3 groups whether they agree to the content and presentation of a list. And then after that, I want to ask the members of the portfolio committee for the input on the predictions, and we will then take it from there. So, in any order, Advocates, you're very welcome.
Thank you very much, Chair. Yeah, I confirm that the presentation that was just now done by Advocate Johar is our work. We have worked through until late last night to produce this final A-list document. The department is very happy with the work done so far. Thank you very much, Chairperson.
Thank you. Advocates Johar and Hercules.
Chairperson, thank you. From my side, I am satisfied that the document that I presented captures what you instructed accurately and is drafted correctly, and as you said, is presented properly in the legalese so as to align it with the rest of the bill. Thank you, Chairperson.
Yeah, thank you, Chair, members. I also agree with my colleague that the that last document presented contains the list of all the amendments and comments considered by the legal team. So we're confident that it addressed the proposals submitted by the committee and the input from the department and the legal issues identified by us as the legal team. Thank you, Chair.
Thank you, Chair. Yes, I confirm that it reflects the discussions from our meeting yesterday with the new proposals that we put forward by the team and committee to consider. Thank you, Chair.
Yes, thank you very much to all of you. I'm very excited that we have come this far. And honorable members, I'm now going to take your hands. It's the process is going to be very easy from here onwards. I'm going to take your input, and after your input, we will take it from there, and I will give some instructions as to how we proceed. And be mindful that we are already at 12:07. I have asked Ms. Majalamba to ensure that we do have some extra time if required, and then we will proceed in this manner. I am looking for hands, honorable members. I see the hand of Honorable Clark. And Chirwa. Only the two hands. Honorable Clark, you may proceed.
And sorry, Chair, my hand is also up.
Unstarted.
Chairperson.
Sorry, Honorable Clark. Gela
Sorry.
fourth. Kaba fifth. In that order, honorable members.
Okay, thank you very much, Chairperson. Just in terms of the insertions on the draft bill, there's one issue in clause 4 that I would just like to raise because it seems very vague to me, where we replaced the word with foreigners. I mean, what happens to asylum seekers, illegal foreigners, or permanent residents? Are they all then clustered into the same connotation as what it's been changed in terms of clause 4? That's just the one issue. However, I would like to express that the DA will not support the insertions that have been made into the bill because we've already voted against the bill in its entirety at the last meeting, and that goes for the same as the A-list. Chairperson, we will not support the A-list at all. So please record that as the DA's objection. Thank you.
Thank you very much, Chairperson. I don't know if I'm audible, but I've got network issues. And thank you to the presenters for their presentation as well. It's just unfortunate that the additions and the subtractions do not necessarily deal with the fundamental issues with the bill that the EFF had raised from the very beginning, that purported our now decision to reject the NHI bill. It is still a bill that is proposing that the government outsource healthcare from the private sector. It's still a bill that raises issues in regards to access, particularly for people living in rural and township areas. Our infrastructural issues and concerns that we've raised are also still not being addressed. And it's just ongoing things that have fundamentally not been addressed by the provisions that have been made by the team. And our rejection of the bill is still sustained because we cannot support a bill that is an admittance that the government is unable to build and resource its own public sector that has collapsed so much that they have to now go out to the public, to private sector, to Netcare and Life in particular, to outsource healthcare at the cost of hardworking South Africans and taxpayers for the short-sighted greed that we've seen even in other aspects and what is unfolding generally in the country. This is just another of the ways of heading into, the direction of strengthening the private sector and weakening the public system, which is unfortunate and cannot be supported by the economic freedom fighters. And that decision remains and is sustained. Thank you very much.
Thank you, Honourable Chairperson. Freedom Front Plus stands by its point of view since the past 4 years in this committee on this NHI bill. And I just hope that the inputs that all the opposition parties made during the deliberations, clauses by clauses, and in this whole process and our legal opinions as well, will be somehow recorded. And if this bill is getting to the 9 legislatures in the country, that they will also have access to that. Nevertheless, to say, I want to place on record that the Freedom Front Plus rejects the Portfolio Committee proposed amendments to Protection of National Health Insurance Bill B11 2019, list number B11A 2019, known as the A list in its entirety. Thank you, Chairperson.
Thank you, Chairperson.
Yes, Honorable Sengwa, thank you.
Thank you, Chairperson. The IFP stand on his own, supporting the bill because they have a huge people who need this. That I still have the mandate of supporting this bill. I thank you.
Thank you very much, Honorable Sengwa. You also support the A list?
Yes.
That has been presented. Thank you. Honorable Gela.
Thank you very much, Chairperson. Chairperson, I rise in support of the presentation and I rise in support of the amendment and the A-list, Chairperson. As African National Congress, we support the implementation of the NHI bill. Thank you very much, Chairperson.
Thank you, Honorable Kaba, followed by Honorable Wilson.
Thank you, Chair. Chair, I rise in support of what Honorable Gela said. I rise in support of the bill and the A list. And thank you to also IFP that it has a vision and the interest of people of South Africa in heart. I support the bill. Thank you, Chair.
Honorable Wilson, followed by Honorable Howard.
Thank you, Chairperson. I will stand with the DA's position and the honourable class on this position. we have rejected this bill in its entirety. This country will not be able to implement it, and let alone fund it, and that we reject the lists as well. Thank you very much.
Thank you. Honorable Harvard, other members have not raised their hands. Be mindful, I'm going to call on you personally, one by one, because you need to express a view today. Honorable Harvard, please continue.
Thank you, Honorable Chairs. Also thanks three legal entities for the nice presentation and amendments. I fully support the amendments. ANC also support the bill. Thank you, Chair.
Thank you. Any other members?
Yes, thank you, Comrade Chair.
Thank
Chairperson.
you, Honorable Nagel. Please continue.
Yes, thank you. I also just want to give my support to this bill. My support is fully with the ANC and with the NHI bill. Thank you very much.
Thank you. Honorable members, let me just remind you of what I'm actually asking you. I am asking you whether you support or not support the A list as presented. I'm going to the stage of adoption of the A list as presented to the Portfolio Committee. So I think we need, because some say we support the bill, but I want you to say that you support the A list. Those who don't support, I've heard you, and if you want to correct it and say you don't support the A list, please do so. Let's go through this then properly. Thank you. I start with Honorable Gela. I restart.
Chairperson, I rise to support the A list. The ANC support the A list, Chairperson. Thank you very much.
Thank you.
Forward with
Next.
NHI. What?
Then I'll mention the names: Kaba, Harvard, Van Staden, Clark. In that order so far.
Chairperson, I rise to support Honorable Gela to indicate that the ANC support the A list and support this bill forward with NHI bill. Thank you, Chair.
Thank you. Harvard.
Thank you, Chair. I rise to support the A list. ANC also support A list and the bill. Thank you.
Thank you. Van Staden.
Chairperson, again, the Freedom Front rejects the A list in this bill in its entirety. Thank you.
Thank you. Clark.
Again, Chairperson, the DA rejects the A list in its entirety, as said before. Thank you.
Thank you. Nagel.
The ANC accept the A list as proposed. Thank you.
Thank you. Honorable members from Honorable Wilson.
Rejected, Chair.
Thank you very much. Honorable members, from myself, I support the A list as presented. I will now name those for and those against, and be mindful of those who are alternate members. Just to remind you what the rules state in terms of alternate members, that when your full-time member is absent, then you are deemed to be able to be counted as a full-time member, and then you don't only serve as an alternate member. I would also want to indicate that the chairperson of a portfolio committee has a casting vote, meaning that chairperson has an additional vote. And today, because this is such an important matter, we need to be very clear on what it is that we are doing. And so therefore, I'm going to count those against. It's and you can tell me whether I'm right or wrong. It's Honorable Members Clark, Chirwa, Van Staden, and Wilson. Then those in support, it's Honorable Gela, Kaba, Harvard, North Nagel, and Hlengwa, and myself. So, honorable members, thank you very much for all the work that had gone into this bill for the past 4 years. We're standing on the cusp of history in South Africa, and I want to really take this opportunity to thank yourselves, the legal services groups, the National Department of Health, all of those who assisted in bringing us to this point to where we are now. I'm now going to give further instructions as to what ought to happen, and then we will be back here on the 20th of May for the following. This A list has to be printed by Frida. It is in the ambit of the portfolio committee to deal with Frida. Once it is printed, the 3 groups of legal advisors need to check the printed documents and finalize it together. The parliamentary law advisor will come on the 24th and present 2 things to us: the printed A list and the printed B bill. And she would be supported by the state law advisors and by the legal advisor of the National Department. I will reiterate that. On the 24th of May, the Parliamentary Legal Services Advisor will bring to us the printed A list and the printed B bill. By then, they would have scrutinized it, they would have looked for corrections, typing errors, any kind of errors which need to be corrected. And they would also have to talk to me about it, or I will talk to them about it with the committee secretary. We would then come back on the 24th and get the 2 printed documents presented by the Parliamentary Legal Services Advisor, supported by the groups of the National Department of Health and the state law advisors. So, honorable members, if there is nothing else, I would then want to call our meeting to an end and to adjourn this meeting. Thank you very much for your indulgence today. This meeting is therefore adjourned. Is there anything that I missed? Anybody? I don't think so. Thank you. This meeting is adjourned.
Thank you, Chair.